So thank you very much for Anurag's introduction. Good afternoon, everyone. I'm very honored to be here to present my work. And we know that human rights have been introduced to address climate change for a long time because climate change is regarded as the common concern of humanity. However, for a long time, the utilization of human rights instruments is limited to the level of being rhetoric. Here I summarize 4 dilemmas for using the human rights instruments to deal with the global climate change problems. The first dilemma is that vertical duties and extraterritorial harm. Human rights law imposes vertical duties, which means duties owed by the state to those within its own jurisdiction. But climate change is the common concern that is expected to affect every country all over the world. The second dilemma is that the legal redress and political verdict, because human rights law is more of legalistic nature, but climate change is often seen as something for politics. So using human rights to address climate change may be viewed as an instrument to reinforce political pressure in the international arena, and the courts may be less willing to address climate change litigations. The third dilemma is the materialized violation with impending threat. The human rights law has the tendency to prosecution when injustice occurs, but climate change is only recognized as an inherently global threat to human rights, and climate change itself is not a human rights violation. Besides, not all infringements can amount to the breach of legal obligations. So the last dilemma is the individual nature and the collective action. Traditional emphasizes individual behavior and fails to consider the need for collective action, while states remain the principal and subject of international law. Emphasis on individual character beyond state borders to solve an environment of global nature is unrealistic. So in practice, solutions to international environmental issues like climate change require states' cooperation and collaboration. So the application of traditional human rights law to address climate change seems to face a lot of obstacles. Therefore, the utility of human rights instruments seems to be rhetorical rather than juridical. However, in today's presentation, I argue that there is the shift from rhetorical to juridical for climate change issues based on the development of environmental rights. So there are many developments in the field of environmental rights to justify this argument. Here I would like to identify 2 trends developed in regional environmental jurisprudence and the constitutional environmental regimes. Firstly, there is a role to play in the regional environmental jurisprudence. For instance, in the European Court of Human Rights, there are a lot of environmental caseloads. So by governing the living instrument of existing environmental law, the court has developed an elaborate and extensive body of case law, which all but in name provides for the right to the healthy environment on the basis of its creative interpretation of Article 2, right to life, and Article 8, right to respect for private and family life. So the court mainly specifies states' procedure obligations. And actually here, this is the same for the Uganda case, the most frequently mentioned climate change case, because the articles are applied directly with the rights to life and privacy in the European Convention on Human Rights as well. So here the Supreme Court of Netherlands upheld that Dutch government has an obligation under the convention to protect these rights from the real threat of climate change. Another example is the Inter-American Court of Human Rights advisory opinion on the environment and the human rights in 2018. So this advisory opinion is a response to Colombia's request regarding extraterritorial jurisdiction of state parties to the American Convention, in particular their obligations under the right to life and personal integrity arising from the operation of the large-scale transboundary projects in the Great Caribbean region. Although it does not expressively use the term of climate change, however, it can be relevant or applicable because climate change is also a kind of environmental harm and risks. So this is a landmark advisory opinion. on the environment and human rights, reaffirming that human rights depend on the existence of the healthy environment. The Inter-American Court of Human Rights ruled that states must take measures to prevent significant environmental harm to individuals inside and outside their territory. So in other words, if pollution can travel across the border, so can legal responsibility. Another role to play here is constitutional environmental regimes. The most important development is the constitutionalization of environmental rights. It provides a legitimization and a justificatory foundation for environmental care in a society and its law and governance system. So constitutional law fosters the comprehensive and holistic approach to the challenge of environmental protection because it facilitates a wide range of legal tools. Meanwhile, it provides grounds for climate change entering the legal and the constitutional domain, so the most fundamental legal area in the nation. And another relevant phenomenon is environmental constitutionalism. Actually, it means the entrenchment of the environment with constitutional importance. About 3/4 of states worldwide have enshrined some kind of environmental provisions in their national constitution. Environmental constitutionalism mainly works in the following two ways. Firstly, constitutionalism is closely tied with basic principles of the society and the legitimacy of the sovereign in decision making, so it can spur stronger or more comprehensive domestic environmental climate legislation. Secondly, constitutional environmental provisions can inspire litigation for environmental protection and climate change because courts have the duty to refer to or to interpret constitutional provisions. Another phenomenon that may be relevant, but we need to argue for, is global environmental constitutionalism. It's mainly related to the normative principles and institutional arrangements, such as the human rights, state responsibilities, and the peremptory norms like jus cogens, erga omnes, etc. So, although we still need to argue for this, but nevertheless, it's our ideal or our objective to expect a solidly integrated, participatory, accountable, and democratic global environmental legal order. So to summarize, there are generally two trends in current development of environmental rights: greening existing human rights law and recognizing an explicit right to the environment. Actually, the latter one is not only happened in a lot of national constitutions, in many regional treaties, such like the African Charter of Human Rights, of Human and People's Rights, Arab Charter on Human Rights, ASEAN Human Rights Declaration as well. At the international level, there are also many declarations and resolutions regarding to the recognition of the fundamental right to the healthy environment, from the Stockholm Declaration, Rio Declaration, to the more recently the draft International Covenant on the Human Rights to the Environment, draft Global Pact for the Environment, and the Framework Principles on Human Rights and the Environment, etc. So to some extent, it can be argued that there is even enough state practice and opinion juris for environmental rights to be regarded as the customary international law. Although the conclusion for environmental rights as an emerging international custom may be debatable, but nevertheless, the development of environmental rights does map the trend for shifting climate change problems to a juridical ground from the following perspectives. Here I summarized here. The first is it identifies the duty to protect, to prevent transboundary environmental harm as the matter of human rights law. This can be based from the Inter-American Court of Human Rights advisory opinion. The second is it raises climate change beyond the level of global politics because of climate change has become, we can argue that climate change has become of constitutional importance as kind of environment protection. And then it facilitates domestic climate performance in terms of legislation and litigation because the role that constitution, environmental provisions, and also the role of constitution plays in the nation. Lastly, it can increase participation democracy and accountability globally, if ideally under the development of global environmental constitutionalism. So, in a word, we should not only focus on the human face of climate change, but also need to look at its environmental fault, and this is where climate change is rooted in. So that's all for my presentation. Thank you very much for your attention and patience.